Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is open. Please be seated.
Good morning, everyone, and welcome to today's sitting of the Appeals Court. I'll begin by introducing the panel to you. To my right is Justice Sabita Singh. To my left is Justice Rachel Hirschbang, and my name is Ariane Buno. I'm not quite sure that yes, I think my microphone is working now. I see people shaking their heads in the back row, so I figure I'm all right. I see people that have already argued before the Appeals Court before, so I'll just say briefly to remind you that each side has 15 minutes, that there is no rebuttal. I also always like to remind the parties that we have read everything you have submitted to us, and so we know that the record very well, and you can get straight to your most salient points when you begin your argument. So that said, the first case I'll call is Commonwealth versus William Knowles, number 2023-1035. Counselor?
Good morning, Your Honors. May it please the Court, Laurie Ischulis for Mr. Knowles. Your Honor, this case really raises in the first issue the question of whether or not the Commonwealth's evidence was sufficient enough to survive a motion for required finding of not guilty on the element of operation in this leaving the scene causing property damage case. And I would suggest to the Court that the most important case that we have in this area is Commonwealth v. Mullen. I recognize that that's an older case, however, it is really the case that demonstrates to us that a second person in the vehicle with evidence tending to indicate that the damage shows that the person arrested or the defendant was not the operator of the vehicle is dispositive on this question.
Could you repeat that last comment you just said? The damage tends to show that the defendant was not the operator?
Correct. So in the Mullen case, the question was who was the operator, and although the defendant was charged with operation, the evidence tended to suggest that he was actually the passenger in the car. And the evidence was based on what happened afterwards. So based on the evidence that showed that the person who was being charged or the defendant was actually the passenger of the vehicle. Similarly, in this case, we have evidence of damage to the passenger side of the vehicle, and we have evidence that when the police happened upon the car 25 minutes later in a different location, and we know that the car had moved locations within the parking lot that the police come upon, we know that the defendant is now in the driver's seat, but he is the one that's injured. All the damage to the vehicle is to its passenger side, but the person who is now sitting in the passenger seat is uninjured. So when we have evidence that tends to suggest that...
So one would have to infer that the passenger in the vehicle would be the one that would have been injured and not the driver? Is that I think that's the point that you're making?
I think, correct, Your Honor, but beyond that, I think you cannot infer that the person who was injured, where the damage was to the passenger side, was the operator of the vehicle at the time of the accident.
What do you say about the blood?
So the blood is, I think it's in my reply brief, if not in the opening brief, the blood is found in the center console. So what's important, though, the defendant is sitting in the driver's seat 25 minutes later. He's actively bleeding at that point, so it's understandable that he's actually in the driver's seat. There's blood there in the center console. But what's important to note is that there's no other blood evidence, like on the steering wheel or somewhere else, that could show that the injury occurred while he was sitting in that driver's seat. The injury could have occurred in the passenger side. And since we don't have any photographs of the passenger side, to my knowledge, we don't know when that injury occurred. So the evidence suggests that whoever was sitting in the passenger side would have been the person who's injured. The blood evidence later found in the console, actually not on the driver's side of the vehicle, really in the center console towards the driver's side, is understandable given that he's sitting there 25 minutes later with an injury and he's bleeding. It doesn't suggest that at the time of the accident he was sitting in the driver's seat. I think that takes a leap of conjecture to get there. It's understandable, in other words, that the blood would be found where he's sitting when the police happen upon the vehicle. But what's very clear is nobody sees him driving or sees anyone driving. There's no description of the driver at the time of the
But
accident.
there is a connection between the car, ownership of the car, and the defendant, and not the passenger.
Right, and as I point out, he's cousins with the registered owner. He does not, the registered owner says, I don't know who was driving the car at that time. The defendant didn't have permission, he didn't have my keys. But the prosecution failed to explore the relationship between Ms. Lennox and the registered owner. There was no questions raised. There was absolutely no relationship or no exploration of Ms. Lennox to the registered owner. So we don't know her connection to the registered owner.
Did the defense explore that?
Not at trial, Your Honor. Not at trial, not to my knowledge. But
So we
again, it's
can't
the
do anything with
Commonwealth's
that then,
burden.
because, well, the Commonwealth didn't have a burden to disprove anything. They only
Correct.
have a burden to prove the elements beyond a reasonable doubt. So the fact that this was not explored, that doesn't help your case or the Commonwealth's case, does it?
Correct, Your Honor. I would suggest there's no adverse inference that can be drawn from the fact that the defendant was cousins with the registered owner, given the fact that the Commonwealth really didn't explore the relationship of Ms. Lennox to the vehicle, and it was the Commonwealth's burden. But like you said, Your Honor, it wasn't the Commonwealth's burden to disprove that fact, but I think in light of the facts that were presented, you really can't take an adverse inference from the fact that...
There's no inference to be drawn from the fact that there is some connection between the defendant and the car. There's no inference to be drawn about his ability to have access to the car?
Well, we don't know the connection to of Ms. Lennox to the car, but I would suggest to this court that in all the cases that I've read where the inference is drawn, that the driver is the operator, and we see this in, failure to stop cases, the driver is the registered owner. In this case, the defendant was not the registered owner, and we don't know who the driver is. So I don't think we can just make that inference so clearly based on the case law. There is a connection. There's no denying that. The defendant, there is no denying that he's cousins with the registered owner. But I think the inference from that he was driving cannot be made.
I don't see, looking at the photographs that were in evidence of the car, I don't see any evidence of a spider web or other crack in the windshield on either side of the car. Is that something that was explored at trial?
Not to my knowledge, Your Honor, and again, it would be, as we see in the Mullen case, it would be the Commonwealth's burdens to demonstrate or to show how those injuries occurred. If they wanted to make that argument that it was the defendant who was in the driver's seat of the, how the injuries occurred, as in Mullen, it would be the Commonwealth's burden to show how the injuries happened.
In Mullen, of course, the defendant had been thrown from the car where on the passenger side, while the other person who the court concluded, was at least equally likely to have been the driver, hadn't been thrown all the way out of the car, but was also partway out the car on the passenger side. So the way those two people lined up with respect to the front seat of the car sort of could lead to a rational conclusion that the other person, not the defendant, had been in the driver's seat. Here, to the extent there's anybody in the driver's seat, it's your client. So when they find the car, right, and I hear you that doesn't mean he was in the driver's seat all along, but I'm not sure Mullen gets quite as far as you want it to get.
So the problem that we have on the sufficiency question is, can you say 25 minutes later, where that car obviously has moved locations? I mean, in Mullen, clearly the accident occurred and the car didn't move.
Right.
In this case, we have an accident occurred, the car's seen later half a mile away in a parking lot in one location. When the police return, it's in a different location, and now the driver is the defendant. But in the previous location, there was no identification of who's driving. At the time of the accident, there's no identification. So that's where the leap comes in, Your Honor. That's where you have to take this leap, precisely because the damage is to the passenger side. We have an uninjured passenger when the police happen upon the car. And so the inference you'd have to make is that the defendant who's injured, now sitting in the driver's seat, was the driver at the time of the accident, when the evidence here, the damage to the vehicle, suggests otherwise.
I guess that's why I asked about the spider webs, and this is way beyond my competence and probably yours too, because it's about cars. But why does the fact that the damage is to one side reasonably lead to the conclusion that the person who was injured was on that same side? I mean, that, Justice Vuno and I are as far apart as two people in a car, and if her side of the car whacked into something, I'm pretty sure I would also feel the effects of that.
So I think your question is
Particularly because you're next to
precisely,
the steering wheel.
Right.
well, I think your question is precisely my point. We cannot make that inference that the defendant was driving because there's two likely inferences here, and they're equal inferences. The only way you can get there is if someone sees him driving, and if there's some evidence from the Commonwealth on how those injuries occurred, I think you can make that inference because no one sees him driving, right? So if we have some evidence on how the injury occurred, then we could make the inference that the defendant was the driver. But without that, we're left without that evidence, and we're left to make a guess on how that he must have been sitting in the driver's side or he must have been sitting in the passenger side. And we see in common with Richet, when that evidence tends to equally sustain two inferences, neither can have said to have been proved beyond a reasonable doubt. And I think that's the actual point. So,
Okay.
and I think we see that, in the Shea case, in the Mullen case, and going forward. And I don't think we've had another case quite like this since the Mullen case where you have evidence suggesting that the person who's been charged is actually potentially the passenger or is the passenger.
Did you want to say anything about the jury instruction
Yes,
before
the
your
jury-
time is up?
Yes, the jury instruction question is very interesting because the judge says he's going to give this circumstantial evidence model instruction, and he cuts out significant portions of that instruction. He doesn't cut out a supplemental instruction. He cuts out actually explanation on circumstantial evidence, especially on a case that's built on a chain of circumstantial evidence. And that's significant because while the judge is not required to use any specific language and he's not required to follow the model instruction, he is required to give a full explanation or understanding of the concepts that the jury is going to be using to make their finding. And when you cut out portions of the instruction, particularly these portions, the jury is kind of left without a full explanation on how to evaluate circumstantial evidence, especially a chain of circumstantial evidence.
So what specifically did the jury not hear in some form?
The specific language on Model 2.240 is, in a chain of circumstantial evidence, it is not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable and that they all be consistent with one another, and together they establish the defendant's guilt beyond a reasonable doubt. That's significant. The next part is, if the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty and that there is no other reasonable explanation of the facts as proven. The evidence must not only be consistent with his guilt, but must be inconsistent with his or her innocence. And lastly, whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all the evidence in the case. That is not a supplemental instruction, Your Honor. That is actually part of the model instructions, and it's significant because that demonstrates to the court and to the parties and to the judge that this should be given when you're giving a circumstantial evidence instruction. This
Seems to me that the passages that you read are concerned mostly with the proof beyond a reasonable doubt, emphasizing the proof beyond a reasonable doubt. It seems like that was also covered.
That is the the Commonwealth's argument, but the problem with that is we're talking about when you're instructing on a chain of circumstantial evidence, that there'd be no other reasonable explanation. And here, the problem is we have another explanation for how, someone else was potentially driving that car or probably driving that car. So we do have another explanation. It is a chain of circumstantial evidence. The other problem comes when he gives the supplemental instruction on leaving the scene of property damage, what could be to a jury quite confusing because it says you can find that the defendant was driving even though no one sees him. That actually is a supplemental instruction. And I would also point out to the court that in the beginning of the case, after opening arguments, the defense does move for required finding of not guilty based on the Commonwealth's opening statement, and the judge denies it. And when he denies this is on the transcript, page 51 and 52, when he denies it, the judge says something, the defense moves for required findings based on the fact that more than one person is in the car and no one sees him driving. Now, granted, this is before evidence is submitted. It's right after openings. The trial judge says that the defense kept harping on that, but according to the jury instructions, it's very clear that no witness has to see him driving in order to find him that he was operating. That is a reference to that supplemental 3 in the leaving the scene of property damage. So I understand that that's prior to any evidence being submitted.
Well, it's not even, it's just a discussion between the judge and the parties.
Correct, but what I want to make clear, what I want to point out is this has been a question from the beginning of the trial. The judge is citing to that supplemental instruction, but then he later fails to give the full instruction on circumstantial evidence, even though he says he's going to, and then later provides us. So in the overall picture, Your Honor, on this trial, just on the overall picture, on what was done in this trial, I'd point that out to the court. I can see my time is drawing near. If there's any questions from the court, I will say with the jury instructions, that, as I say in my reply brief, I do rely on that Rosa case to find that the Commonwealth's burden was lessened, and that is the case in addition to the Dotsey case that I would like to rely on as well.
Okay, thank you very much. I'll check with the panel to see if they have any follow-up questions. I see none. Thank you very much for your argument.
Good morning. May it please the court, Kristen Jang for the Commonwealth. I'm happy to start with the first issue in the case, which is sufficiency. And I think in the light most favorable to the Commonwealth, there was a substantial amount of circumstantial evidence in this case showing that the defendant was the driver of the vehicle. I think most significantly, he was found in the driver's seat of this heavily damaged vehicle, still running 20 minutes after the accident. He was bleeding from his nose, and police observed drops of blood and a bloody tissue on the driver's side. And I agree with this court's confusion about what the fact that there was damage to the passenger side of the exterior of their vehicle, whether that has any, whether that indicates that the passenger necessarily was more likely to be the one injured in this case. I think it's a very reasonable inference, and perhaps the most reasonable inference, that it was the driver who was injured because of the impact his nose hit the steering wheel. That's just, to me, the most obvious explanation for what happened, and the fact that the defendant was the one with injuries to his nose and there was blood on the driver's side of the vehicle is just further proof that he was operating the vehicle at the time of this accident.
But your sister points out the fact that there was not sufficient evidence to really connect that injury to someone sitting in the driver's seat. What I'm hearing you say, your point is that one doesn't need that because one could assume that if someone's in the driver's seat, whoever that person might be injured at the bridge of their nose, unless you're kind of my height, which might be you would be hitting, you would be injuring something else, your chin or something, or your forehead. But that's, you say there's that was not necessary in your view, because a juror can make a reasonable inference on that.
I think that's a very reasonable inference to make, and the standard here is in the light most favorable to the Commonwealth. So the defendant certainly could and did argue that it was not sufficient and presented this theory that it was the passenger in this case and that the defendant was trying to protect her and took the fall. But that is not an inference that I think was more reasonable than the Commonwealth explanation for what happened. And based on the standard that we have to apply here, I don't think that that calls into question the Commonwealth's theory. As to the second argument on the jury instructions, I think the case law is pretty clear that we have to look at the jury instructions as a whole, and that there is no requirement that the judge has to give the exact instruction requested by the defendant.
But do you have any theory as to why the full instruction wasn't given?
Perhaps it was just, I don't, actually. This was a district court one-day trial. You know, it could have just been a mistake, honestly. But I think the fact that there was no objection from defense counsel is further proof that this wasn't really prejudicial to the defense, that it was everything that the defense wanted the jury to be instructed on was covered adequately. And I think there's plenty of cases to support that, including even, honestly, Rosa, which the defense cites to. Even in that case, it was found to be no substantial risk based on the evidence presented and the overall instructions. And I'm also happy to touch on the closing argument and direct. If there's no questions on that issue, I'm also happy to rest on my brief.
I'll see if the panel has any further questions for follow-up. None here. None here? No.
Thank
you
you
both
very
very
much.
much. Between the two of you, you have crystallized the issues for us, and so we'll take the case under advisement and get back to you as soon as we can. Thank you. I'll go down here. Thank you. We will. All right, the next case on our list is Commonwealth versus Kenton Thomas, 2023-1019.
Good morning. May it please the court, my name is Alan Campbell, and it's my privilege to represent Kenton Thomas in this appeal. Mr. Thomas is asking that this court reverse his conviction for manslaughter and remand for new trial. Excuse me. I've raised 4 issues in the brief. I doubt we'll get to all of them, but hopefully we can cover at least 1 or 2 of them. And the first issue I'd like to address is that the PDF was not adequately redacted. And this was
So
either...
let me ask you first about, where's our factual predicate for this argument? The record.
You have the copy, the PDF, you can look at it. It is very easy. You right-click on it and you will see that it's not a redaction, it is simply a highlighting.
But those aren't the facts that we need to determine whether or not there was any prejudice to your client, right? What we need to know is whether or not that ever happened.
Well, the jurors were instructed to look at everything that they were given, to consider all of the evidence, and that everything they were given was evidence. They were given the PDF copy of it, they were given a computer on which they could access it.
But weren't they also admonished not to mess with anything?
They were not. They were admonished not to speculate or guess. They did not have to either speculate or guess. They could right-click on it and see exactly what was underneath it.
Did they?
I don't believe we're allowed to ask the jurors about their deliberations and whether they considered the exhibits.
Well, was there evidence that they did?
That there wasn't, but again, this isn't an extraneous influence. This isn't, did you see something that was on counsel table? Did you hear something? This was an exhibit that was given to the jurors, and they were instructed to consider the exhibits.
Well, not exactly. There was extraneous information in that exhibit they were not supposed to see. So I think it is analogous to an extraneous influence on a jury.
I would differ. Hopefully you agree
Okay.
with me. Because the PDF wasn't properly redacted. It was given to them. This argument doesn't exist if the Commonwealth doesn't introduce an extra copy of it on a PDF. But it was introduced. It is part of the record. You don't have to do anything crazy to it. Frankly, I discovered this while I was creating the appendix. I happened to click on it by mistake and said, wait a second. I right-clicked on it, a little black button appeared, I touched it, and it turned light green, and I could read it.
So now you've answered a burning question that's outside the record, but now we, because there's no motion or anything before the trial court to explore this, et cetera, but that's okay, we'll leave that as it is. Back to the question of whether or not the jury ever did what you are surmising happened here, right? I guess there's 2 questions. One is, are you saying just the possibility that could have happened is sufficient for your argument? And if that's the case, that's one argument. Or do we need to determine whether or not it actually happened? And would you agree with us that we would not be in a position to determine that? Because that's a factual issue.
My argument is actually based on the possibility that it could have happened. And given the instructions, this is an exhibit. The exhibits are evidence. Consider all of the evidence.
So what's your best case for just the possibility of something like that having happened is sufficient for reversal?
Specifically as to that, I do not have a best case. This is based on general principles of the exhibits that are entered are the record. This PDF is part of the record.
So let's assume that that it was entered, it's part of the record, and that's manipulable in the way that you discovered. How does that fact, without knowing whether the jury actually, this is a horrible sentence. Let's assume everything you're claiming happened. How do you show either a substantial risk of a miscarriage of justice or ineffective assistance based on the possibility that the jurors manipulated it?
Well, they're actually very similar, because the exhibit that they were given had information that they were not supposed to see. They could have seen it. That is the ineffective assistance is not ensuring. The trial counsel did a great job on this issue otherwise. He secured a large number of things that should have been redacted, and they were redacted from the paper copies, and they were redacted properly from the video.
And the jury, I just want to make sure I'm following the facts here. The jury got the paper copies,
Yes.
and the jury got the video.
Yes.
Okay, please continue.
Which were both redacted.
Which were both
Appropriately,
properly redacted.
right. Mm-hmm.
But they also received the copy that had
Got it.
prejudicial information.
But so if you look at it under the ineffective assistance sort of claim, how do you establish prejudice?
Well, the prejudice is that the information that they shouldn't see was quite damaging. It's references to him having been arrested, having been in the
But don't you have to show that as a result of what counsel did, that the jury actually were exposed to that information?
Well, as a
Okay.
result, what counsel did was he did not ensure that the PDF had actual redactions on it. And attorneys working in this day and age should know about PDFs and should be able to determine whether or not it's a redaction or a highlight.
Oh, boy. I don't know what kind of bar that is, I have to say, because apparently nobody realized that. So it wasn't just this attorney, it was also the prosecution, right? And it was not some,
Maybe I have more experience with this because I have to submit documents by PDF to the court. And if I submitted a document that had inappropriate information and it was not redacted but merely highlighted in black, I would hear from it. And if it involved a case, for instance, of sexual misconduct, I might hear from it with a letter saying, could you please explain why you haven't violated, and I forget the law, which requires not putting that information out there.
Is there, I'm going to ask two questions, and I'm going to ask them in the wrong order. One, is there anything in the record that shows which side actually did the redactions? And two, does that matter at all to your argument?
I believe the record indicates that the Commonwealth did the redactions. I wouldn't bet my life on it, but I believe the Commonwealth did the actually did the highlights, I should say, to the file. I don't know that it certainly doesn't matter for the substantial risk portion of the argument which side did it. For the ineffective assistance counsel claim, it may have been better if my attorney had done it, because then it would be a more obvious error. But regardless of whether he made the highlights by mistake or he didn't notice that they were highlights, the effect is still the same, is that very highly prejudicial case information went to the jury in a very close case. But I think that issue is relatively clear, and unless there are no additional questions on that one, I'll move. And I'm actually just going to follow the order of the brief. The next argument is that Thomas was unfairly prejudiced by the introduction of evidence that approximately 7 weeks after the incident, he was carrying a pocket knife. I know there are many cases that say evidence that a defendant had a weapon that could have caused the crime is admissible. However, on the facts of this case, it should not have come in. Under Creighton, the standard is even if it's admissible, if the prejudice outweighs the probative value, it should not come in. And the carrying of a knife 7 weeks afterwards, when there was no evidence that the knife could have actually caused the injuries, does not make it any more or less likely that the defendant was the person who Jean identified as the attacker. The cases that the Commonwealth relies on are somewhat distinguishable. For instance, in Colton, that's I think the most recent case the Commonwealth relied on. That was a gentleman had a collection of knives at his home. They were introduced. But there was another element to it. In that case, that if there was evidence that the defendant was at a party, he didn't have a knife, he went to his home where the collection was, and then he stabbed somebody. So the collection of the knives there actually went to premeditation, with an argument that the Commonwealth said that he went home, armed himself, and then performed the act.
But in Colton, the defendant also confessed that the weapon that he had actually used was in the river, and then a weapon was recovered from the river. So my understanding of the ruling in that case is that it's the SJC says the knives recovered from the defendant's mother's house were admissible as weapons potentially used to stab the victim, notwithstanding the fact that the weapon that the defendant said he used to stab the victim was in another location.
Right, and that part of the reason was there's no fingerprints evidence to that extent.
Right, which is also true here of the weapon found in the sewer,
But in
right?
Colton, there was the additional fact that the knives at the house were actually relevant to the Commonwealth's theory of how the crime happened, that the defendant went home, grabbed a knife, and then stabbed the person. So having knives at your home, a collection of knives at your home actually supports that. Here we...
And everybody has knives in their homes, right? I mean, because you're also arguing that in this case, it's not so distinctive. People, some people carry knives.
That's true. Some people do.
But in that case, even though plenty of people have knives in their homes, it was still considered relevant.
It was, but again, you have to weigh the relevance to the prejudice. The relevance in this case is essentially nil. He carried a knife 7 weeks after the fact. There's no evidence that he carried a knife beforehand. And along that line, James, which is another one of the cases, relied on the Commonwealth's in that where knives recovered from defendants' homes were allowed in. Those knives had been recovered pursuant to a search warrant. Part of the affidavit and the evidence to that was that the defendants regularly carried knives at the time of the incident. In this case, there is no evidence that the defendant regularly carried a knife. So the fact that he carries one 7 months, or 7 weeks rather, after an incident, it really doesn't add anything. And I would agree that even as the judge mentions, carrying a knife isn't in of itself super prejudicial, but it's also of zero relevance. So even a little bit of prejudice
Well, I
can
don't
outweigh
think it's
no
of
relevance.
zero relevance. I mean, if you stop two guys in that area and they both have knives, and, I think that Mr. Jean testified that he had carried a knife until he was stopped with one, and then he stopped carrying it, right? So the fact that these two witnesses have knives doesn't seem to me to be irrelevant to the fact that someone was stabbed with a knife in that area.
Well, this wasn't two people stopped in the area. This was somebody arrested 7 weeks after the fact. So it's not like he was leaving the scene and had a knife on him, or was in the area around the time, or even before the incident had it. This was 7 weeks after the incident. He had a folding knife, which also happened to be a serrated knife. There was no evidence whatsoever as to what type of knife could have caused the wounds on Mr. Nordis.
But the judge didn't rule differently, right? The judge said it was relevant because different wounds were inflicted. And that was the ruling, correct?
I think the ruling actually was more of the jury's going to hear about a box cutter, the jury's going to hear about Mr. Jean's knife. Why shouldn't they hear about this third implement?
Right.
And
So
the reason-
summarizing, in other words, that there were multiple implements that were used.
Right, but this wasn't recovered at the scene. It wasn't recovered in the immediate aftermath. It was recovered, again, I'll say it again, 7 weeks. I might be off by a little bit, but it was substantially after the incident. And what we know that the jurors weren't supposed to know is that he apparently had left the area and then come back. I mean, left the area, like left town a little bit, and then come back. It didn't come in at trial because there was no evidence to suggest that it actually was consciousness of guilt, because they didn't know he was looking for him or whatnot. But let's stretch it out. Say he had been arrested 4 years later with a knife on him. Would that have been relevant to say that he might have had a knife 4 years prior?
Well, that's stretching it. You're absolutely right. Stretching it out is also stretching the analogy a bit there with 4 years. You may have had a better argument with that, but.
Can I divert you briefly in your remaining time to talk about just a factual question? I don't know if it's available in the record, whether the psychologist was in the courtroom during jury selection?
There is nothing in the record to suggest that he was in the courtroom during.
Is there anything to suggest that he was not in the courtroom during jury selection?
There wasn't. However, it was clear that defense counsel was not to be interacting with this person during jury selection.
Oh, I understand the consultation was to happen outside the courtroom. You argue that, and I think that's clear from the ruling, but I just wondered whether the person was there or not.
Yeah, there's nothing in the record one way or the other.
Okay,
to
thank
suggest that. Then in my 15 seconds, I will not start a new issue, but hope that you take a look at
Everything's fully briefed, and of course you know that nothing's waived that's been fully briefed, so you don't have to worry about that. But I will see if there's any other follow-up questions. This side, no. Thank you very much.
Thank you.
Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth.
Good morning.
I'll start on the first claim. The defendant says in his brief that it is likely that the jury viewed the blacked out portions, or I should say the shaded out portions, on the PDF because of three specific instructions that the judge gave. One was that everything submitted to them was evidence. The second is the jury should consider evidence as a whole, and third, they consider all of the evidence. And I think it is a huge stretch to say that as a result of those three general instructions, especially in light of the repeated specific instructions that those blacked out or shadowed, whatever they are not before you. You are not to consider them. It is a huge stretch to say that as a result of that, they bypassed the copy that they had of the transcript, the audio and video of the transcript, and went and looked at that thumb drive. There's no evidence as to whether or not they ever looked at the thumb drive. There's nothing in the record that shows that they asked for assistance to use the computer or the device. But as Justice Singh has said, we don't know whether it's technologically feasible. We don't know on some PDFs, many PDFs, but we don't know what version of Adobe Acrobat. I'm not saying that we ought to remand and find those out because I don't think it's relevant, because I think it's virtually impossible. I think it's unreasonable to assume that based on those three instructions, they would have actually
Well, would it be reasonable for a motion for new trial to be filed on this? And do you think it would be reasonable if a motion for new trial had been filed that, for example, court officers could have been interviewed? Did any juror come up and ask a question about this? Could the jurors be interviewed? Did you look at this? Not asking what they deliberated, but could you look at this? Are those the kinds of questions that you think could be resolved in a motion for new trial versus a remand?
I'm not sure the extent of the power of the judge to make those inquiries, but I would suggest that this court can certainly decide now based on the record, because there was neither deficient performance nor prejudice. So that really doesn't matter whether or not they did it. And I say there's no deficient performance because the counsel in this case went to extraordinary lengths to make sure that every possible part of that statement that might be redacted was. He prepared a document for the court that was shadowed, that had green shadows where the parties had agreed and blue shadows that were contested. And there's a large part of the transcript where they go over line by line, and the judge looks at each part where there's not agreement and says yes to this, no to that, yes to this, no to that. Counsel made absolutely sure that the documents of the paper transcript was all blacked out, and the audio video was also properly redacted. There's no claim that those documents included anything that had been excluded. And to answer Justice Hirschfang's question, the record shows that the Commonwealth prepared the video exhibit. It's something called the Suffolk County Multimedia Unit, which prepared that. It appears, though I'm not sure from the record, that the Commonwealth also prepared the transcript. That I'm not absolutely sure about it. But I don't think it matters either way, because there's been no complaint that those were improperly done at all. And so I think that even if the defendant met the second prong of Zafarian, and I absolutely don't think he didn't meet the first one either, because it would not have been an ordinary fallible lawyer. It would not be substantially below that person's conduct for him not only to have done everything that he did, but to ensure that the PDF that was on the thumb drive that might have been accessed by a laptop could, in theory, have been looked at by the jury in violation of the specific.
Well, I've got just a hypothetical. What
Sure.
if the PDF didn't have any redactions? It was a mistake. The actual whole original transcript with no redactions, shadow, this, that, or the other, was put on because some of us are fallible and make mistakes with our computers all the time, right?
Of course.
What if that had happened? Would it have been below what you would expect from an ordinary fallible lawyer to not check the actual exhibit, like open it up and check and make sure it was what everybody thought it was?
No, I don't think so. I think that it would be fairly common, not always, but fairly common for defense counsel to assume that the copy that was on the PDF. I mean, it is obviously better practice for him to have, or for her to have said, well, let me take a look at the PDF beforehand and make sure that they
Well, you
are, but
always
I
look
don't
for,
think it's-
sorry, I don't mean to talk over you, but you always look, for example, at photographs and exhibits. Okay, that's the knife, that's the 10 autopsy photos, up these
Right.
up photos 12 through 15, they were only, they were for ID only, take them out of the pile. That kind of stuff happens.
Right, but here, though, there are three types of that exhibit. There's the transcript itself, there's the tape, the audio video tape, and then there's the PDF. So you have to, first of all, think that they wouldn't look at either of the first two, that they would go. So it's not the only piece of evidence on that they have. It is much, much more likely that they looked at the paper copy or watched the audio. The chances
I could
that-
totally agree with you and still think that maybe they should have checked the PDF. I mean, I certainly see your point, and we asked counsel about this, about, where's the real, factual predicate, as Justice Singh put it, to say that this happened or didn't happen, as also Justice Hirschfang brought up, right? But I'm just asking, in today's day and age, a point that your brother has made validly to my old ears, what is expected of counsel when we have electronic documents? It's easy when it's a photograph, easy when it's a knife, easy when it's a set of keys, all that kind of stuff, right? But what would be
But
required?
The standard is his conduct, his performance has to be substantially below what might
Got
be
you there
expected.
too. Okay, what would be substantially below? Can you give me an idea?
Well, if you had not checked the paper transcript, if the paper transcript had only some of the redactions done and not all, or none at all, that certainly would have been deficient. Or had the audio video not
Right,
been
because you could
properly
have
redacted.
quickly taken a look at that paper transcript, right? Boom, boom, boom.
Pardon me?
You could quickly take a look at the paper transcript,
Yes.
right? So why shouldn't
The audio video.
why shouldn't the same attention have been paid to the PDF?
Well, because that was the third, because it was in a way superfluous. It was just that exhibit, the prosecutor had a practice at trial. There's a ton of exhibits on that thumb drive. That was just his practice. Almost every time that he had an exhibit admitted, he put it on what they call the purple thumb drive. So it's not like that was the only thing on that drive. A ton of exhibits. This court has a copy of that purple thumb drive, and you will see, or I'm sure already have seen, there are many, many other documents there beside the statement of the defendant. So there are so many layers and levels that the jury would have had to gone through to review it that I think it's highly unlikely. And I don't think that on pain of reversal that counsel would necessarily have to ensure that that PDF on that thumb drive filled with other documents was not able to be manipulated. And that assumes juror misconduct, I think, because they were told explicitly. It's not just, I don't think that they would have looked at it because of those three general instructions. They would have had to engage in misconduct by doing that, having been told explicitly, you're not to view those. So I don't think that effective counsel has to take into account the possibility that this juror is going to not follow the instructions. And of course, they say over and over that these exact instructions, we presume, are followed. So that's what would have had to have happened for the jury to have done what the defendant said he likely did because of those general instructions. And of course, we don't know whether they did, nor do I think we could find out. I also don't think, and if you don't mind, I'd like to move to the prejudice aspect of it, which sort of dovetails. Why I don't think that even if the jury had seen the blacked out portions, they would have found any differently. Prejudice in this case means acquittal. He was found guilty of involuntary manslaughter. The verdict slip had three options: second-degree murder, involuntary manslaughter and not guilty. So in order for there to be prejudice on any of the 4 claims, the defendant has to show, or because they are preserved, we have to show the standard for prejudicial error, that the jury might have found that Jean stabbed the victim and not him. He put himself at the scene. So there's no question that it's either Jean or the defendant. And there was a huge amount of evidence at trial that the defendant was the stabber, not Jean. So the likelihood that the defendant would have been altogether acquitted of anything had they viewed the statements on the portion of the statements that were blacked out, or had these alleged errors also been errors. There's a piece of evidence that I'd like to point out that I didn't stress in my brief. The defendant's statement, I think, is far more incriminating than the defendant admits. He talks about being bullied. He talks about, and I would point the court to the bottom of page 20 of my brief over to page 21, which is also pages 122, 23 of the appendix. And the defendant is speaking hypothetically, he says, and I'm sorry to read out loud, but I think it's very, very important that the court focus on this. He said to the officers, "You don't have any idea what it's like when you walk away from a situation, just hypothetically speaking or whatever, you walk away from a situation and in your mind you're thinking, the next time this particular person will or won't, bother this person, whatever, and then you get word that somebody died. Your heart jumps out your effing chest." Now, that is the language of lived experience. That is not someone speaking hypothetically of what might have happened if you had attacked someone, didn't know that person had died, and then later found out. This has the ring of the person who did the stabbing would feel that way. And he also, I'm sorry, Justice Vuno, it looks like you wanted to.
No, I was looking up something.
So I think that is very powerful evidence, along with all of the other things that he says. He says, well, I'm speaking hypothetically, I shouldn't have said that. Well, no, he shouldn't have said that, but that doesn't mean it's not true, because he later says that it's hypothetical. Also, I think the order in which the people came out from the church and the ABCD family planning is very, very important. The video first shows a man running out, turning right onto River, then left onto Edgewater, and that's the person who puts the knife down the catch basin. The next person who comes out is wearing a distinctive vest, and we know from the clothing that was seized from John and John's own testimony that he was the one who was wearing the vest. So it makes sense, and it aligns with Jean's testimony that the defendant stabbed him, ran out first, and then he came out later. And then a few minutes later, the victim himself walked out. So I think that shows very clearly that of the two of them, there was much, much stronger evidence that it was the defendant himself who did the actual stabbing than Jean. So I think that even if the jury had read these blacked out portions, even if they had not heard that the defendant had a folding knife on his person 49, and it was exactly 7 weeks, 49 days later, they would not have found that Jean was the stabber. And the same is true with the jury consultant and the fourth claim.
Can I ask you about the folding knife? Why was that relevant? Why would the Commonwealth choose to fight that fight about admitting that knife?
Well, for the very reason that all of the cases say that it's admissible to show that it might have been the murder knife. If that's on, and I think that the Colton case is almost scary how on point it is. He said, I threw the knife into the river. They found the sheath knife, and then they go and find 2 more sheath knives at his mother's house. It is to show that he had access to the weapon. And yes, virtually everyone has access to knives, but the SJC has said over and over that this principle, which of course the paradigm case involves a gun, but it also applies to, that's because it could have been the murder weapon, because the medical testimony was that you couldn't tell whether it was a straight blade or a serrated blade. And I also think that the judge acted within her discretion when she found that so the jury could get a full picture of the case, they would know that everyone had a knife. The victim had the box cutter, the defendant had the catch basin knife, or the stabber had the catch basin knife. And so it was fair for the jury to get a bigger picture. And her conclusion that basically the jury were sophisticated enough to know that people in this area, that's the milieu where the crime occurred, that it's not going to shock everybody to find out that they'll be able to know, okay, a lot of people have knives in their pocket. But I think the Commonwealth was entitled to show, because the defendant said the catch basin knife, I didn't do it. So he's saying, of course, there's no evidence on that knife because it had been washed, exactly like in the Colton case, that this might have been. I don't think it was the most important piece of evidence, obviously, but I think it did have some probative value for the Commonwealth worth fighting for. I'm not saying that it was essential to the conviction, but I think that the prosecutor is entitled to present as much evidence as he or she can to prove his case, which, of course, we have to prove beyond a reasonable doubt. I see that my time is almost up. I'll be happy to take any further questions. Otherwise, I will rest on my brief.
I will check with the panel. And I see no further questions. Thank you both very much. Oral arguments were very helpful. We appreciate it.
Thank you.
Next case on our list is Commonwealth versus Jerome Federico Fletcher Diamond, 2024-0132. Good morning.
Good morning. May it please the court, my name is Attorney James Methy. I represent Jerome Fletcher Diamond in this appeal. One little side note before I start. I left my house in Ludlow at 5 a.m. this morning because I usually leave at that time to kind of beat the rush hour traffic. And the snow was horrendous. I mean, it was, until I got to Worcester, the visibility was very bad.
I'm glad you're here safely. I can sympathize since I come in from Northampton. So I was smart enough at my age to come in last night so that I wouldn't have to have that snow this morning. Yeah, that's exactly what happened. But as an aside, I promised my family that. So maybe you should make the same promise in the future.
That's a good idea.
All right, you're here safe and sound, and you have an interesting case for us to hear about today. So.
The first issue in my brief concerns two statements that were made by the prosecutor in her closing argument that create a substantial risk of a miscarriage of justice. The first statement, I'm quoting it, whether the arguments put forth by counsel on behalf of the defendant truly matter, end quote. And the second statement is, quote, Officer Levesque, the defense attorney, gave him a hard time, end quote. Now, the judge did tell the jury twice that the arguments of counsel were not evidence, both at the time of the openings and the closings. I would argue, though, that the two statements are certainly improper. Stating that what defense counsel says in his closing argument doesn't matter is basically saying just completely disregard what defense counsel says because it doesn't matter and just basically listen to me because what I say matters. And saying he gave the officer a hard time is basically criticizing counsel for trying to do his job, basically by cross-examining the officers, and there were a lot of witnesses in this case. I think there were 19 witnesses, and he did a good job cross-examining them. And then to say that he gave the officer a hard time, he's got a right to rigorously cross-examine the witnesses because that's basically the defense. I mean, other than the defendant's testimony, all he can do is cross-examine the Commonwealth witnesses.
So how do you distinguish the decision in Commonwealth versus Roberts when it comes to the statement about giving the witness a hard time?
I don't recall exactly the facts in Roberts. Is that a case that I cited or the Commonwealth cited?
Well, I don't know. It's a case I read. Who knows where I got it from other than the internet? But the Supreme Judicial Court concluded in that case that the prosecutor's closing argument, criticizing the cross-examination of a witness was fair game. So that, the prosecutor accused defense counsel of belittling human beings And the SJC says it was not improper for the prosecutor to comment on that defense tactic.
I know there's a number of cases, obviously, on prosecutors' closings and some kind of and similar language that I cited in my brief. And
Well, in the case, I think that's probably best for you, the prosecutor called the defense tactic, or a tactic by the defense lawyer, despicable. And the court said, no, you can't, that's commenting on, not on something that the jurors themselves observed, but actually an attack on the person, that, you know, that you are a despicable person for making this argument. And that's a distinction that would seem, as applied, not really to help you in this case, because the comment you're challenging, or the one that I'm talking about, was talking about what the jurors had seen in cross-examination. I mean, they saw a defense lawyer giving a cop a hard time. Like, that's happening right now in some courthouse in the Commonwealth, right? That's trial.
isn't that despicable comment kind of similar to saying that he's giving them a hard time? Isn't that somewhat despicable, I suppose, if you characterize it that way?
Well, I think that's the distinction that the cases make, is that, you know, the SJC has seen those two things differently, at least as I read these cases.
The prosecutor made a number of objections to the defense counsel's closing. I think there were 5 objections that she made, and I guess there was somehow to justify, I would argue, didn't justify what she said, but to her, I guess that was her justification. But her objections were to defense counsel's closing, where his use of the word "I think," which I found to be, I think, 3 sentences in a 36-page closing argument, so I would call that pretty minor, although the judge did somewhat agree and did instruct the jury that after that opinions of counsel are also not evidence. But all her other objections were not really agreed to by the judge. He said to defense counsel's statement about it was despicable that there was no forensic testing. He said, well, it's close to the line, but I don't think it goes over the line. So basically, the only prosecutor objection that he agreed on was his use of the word "I think," which I would argue is a very minor transgression, and it certainly didn't justify what she said to the jury in her closing. I move to the second issue of my brief, that the judge should have allowed the required finding of not guilty on the indictments. I realize that the alleged victim, Yasimi, and her son, Jeremiah, testified that my client was in the house.
And her daughter.
The daughter didn't testify, although
The hearing on the motion to dismiss included testimony from the responding police officer, which included statements from both the daughter and the son identifying your client as having been the one in the house at the time.
All right, so I understand that 2 or 3 people testified he was in the house at that. Well, I know that the daughter didn't testify, but anyway. And I understand that the judge has to take the evidence in the light most favorable to the Commonwealth. I would just argue that the defendant testified in this case and gave an explanation as to where he was that morning, and afternoon and evening, and that I would argue that that degraded the Commonwealth's case at that point. And there was also a number of other odd things about the evidence in this case that I think the judge should have considered when considering the motion. And some of those things were testimony, even from Yasimi, there was no hostility between the parties, which really meant there was really no motive for my client to stab her, or no reason even, besides a motive. There's no knife found either in Watertown or in Fall River, even though there were multiple police officers there, and they searched for the knife, didn't find one in Watertown or in Fall River, even though they said that they chased, I guess it was my client in Fall River. He ran by him with a knife, ran by the officer with a knife, they chased him, they brought a dog out to search, and they still couldn't find a knife. A person escaped from the house in Watertown twice, which is bizarre because there's a number of police officers there. Somebody comes out of the basement, he runs, gets into a car, then they freeze the scene, and then all of a sudden, somebody's back in the basement and comes out again, and they can't find him. They chase him, and he gets into a car again. Very bizarre. The only blood on the car is in the driver's side door panel, which is bizarre again because they tested the other parts of the car, the steering wheel, the controls, no blood on anything else, which is bizarre. So my client's driving the car, there should have been blood on something else.
But we're talking here about two things, right? We're talking about whether there was probable cause to arrest and whether the evidence sufficiently established your client's identity. So what the arguments you are making are that there was contradictory evidence available, and I think that's obviously true. But the assessment at the point of indictment by the grand jury and then at the point of the challenge to the indictment by lawyer for the defense is whether or not there was probable cause to believe that this guy committed the crime. So the evidence in support of the fact that it's this guy is the testimony of 3 witnesses who are intimate family members who lived with him, that it is this guy. Are you contesting that that was insufficient to support identification?
Actually, Your Honor, I'm not arguing the grand jury indictments. It's just the motion to dismiss, right? I'm arguing the motion for required finding of not guilty, which
I'm sorry, I thought you were talking about the motion to dismiss.
No.
All
I'm
right,
not talking
my
about
mistake.
that, although
I apologize.
But you do raise that in your brief. You raise it both.
I did.
Okay,
It's my
right,
third
all right.
issue. That was another.
Okay.
Right,
Okay.
I did argue that in the brief. But this argument goes to the required finding. So you have, in addition, you have the defendant's testimony, and I'm arguing these other points of the evidence being insufficient. But then the last point I want to make on it was no forensic testing done on any articles of clothing, including my client's sweatpants, which would have at least verified or attempted to verify what Yosemite and her son testified to at the trial. I'm going to skip now, if there's no other question on that issue, I'm going to skip to the fourth issue in my brief, which the judge abused his discretion when he allowed Lieutenant McManus to testify as an expert on cell site location information. I would argue that Lieutenant McManus wasn't qualified. At the voir dire hearing, I'm talking about the voir dire hearing before the trial, and based on his CV that was attached to the Commonwealth's motion to admit his testimony, there's very little about his education and cell site location information or training. He testified at the voir dire, he's testified as an expert on human trafficking, and it's also on his CV, but no testimony about that he testified as an expert on cell site location information. Again, no previous testimony, there was no testimony at the voir dire that he'd ever testified as an expert on cell site location information or anything on his CV about it. Secondly, I would argue that there's no testimony at the voir dire as to reliability of the software he used. He testified at the trial that it was widely used by the departments, but there's nothing at the voir dire about the same testimony that's used by other departments or any reliability testimony. So based on those factors, I would argue that Lieutenant McManus shouldn't have been qualified as an expert and shouldn't have been allowed to testify in the case.
And if the evidence was improperly admitted, you would need still to show prejudice to your client through its admission, right? What is the prejudice?
Well, the prejudice is, Your Honor, that it went to his somewhat alibi defense that he wasn't in Watertown at the time of the crime. And Lieutenant McManus's testimony and the maps he presented appeared to show that there were calls made from the Watertown area at that time. So it did prejudice his testimony, the fact that it contradicted his defendant's testimony.
And it's not the evidence that he was in Watertown, the cell site information that your client was in Watertown is not cumulative of the 2 eyewitness testimony. Why?
Well, it attempts to verify the eyewitness testimony and contradict the defendant's testimony. If there's no further questions, I'd ask you to reverse the judgments. Thank you.
Any further questions? Counselor?
Good morning. May it please the court. My name is Emily Walsh, and I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The prosecutor's closing argument was proper and was a fair response to the defendant's argument regarding the hard time statement. It was a fair response to the defendant's closing, which stated the Commonwealth's witnesses fought me tooth and nail throughout this entire trial. The victim fought me, Detective Connors fought me, Officer Colon fought me, Officer Levesque from Fall River fought me on almost everything. Further, the comment could be reasonably interpreted as counsel conducting a thorough cross-examination and is not a character attack. Regarding the truly matter comment, defense argues that this improperly criticized the defense. In context, the statement was, don't leave your common sense and life experience at the jury deliberation door, bring it in and apply it to the arguments the defendant wants you to buy in this case, because only you can decide as the jury whether the arguments put forth by counsel on behalf of the defendant truly matter in deciding the issues in the case. This can be reasonably interpreted as asking the jury to focus on the evidence and use common sense rather than accept the arguments of counsel. The motion for required finding was of not guilty was properly denied. The defendant argues that the absence of specific evidence, absence of motive, the knife used, and DNA evidence renders the evidence insufficient. That is not correct. None of the evidence cited by the defendant is essential to proving the Commonwealth's case. There was sufficient evidence of identity before the grand jury where the victim, a family member of the defendant, identified him as the person who attacked her, and the CSLI in the case was properly admitted, and Lieutenant McManus's testimony, expert testimony, was properly admitted to address the CSLI.
What was his expertise?
He testified that he had a GIS degree, a Geographic Information Systems degree, a master's degree with a concentration in Geographic Information Science, which he described as analyzing data and mapping and doing projects using geographic information systems.
So the expertise was mainly in his education.
So at trial, I'm not sure. I have the date as 5/12/23. I don't remember if that's a pretrial hearing. He did testify, my recollection, and I don't have a specific transcript site in front of me, that he trained other people in how to use GIS and CSLI mapping, and that he also had done it himself. I don't think that it is only education, but he certainly had a lot of education on the matter. And my recollection is that he had testified for it before, but also comparing this case to other relevant cases, like the case that I cite in my brief, where a T-Mobile manager who really wasn't able to explain anything about CSLI or apply the CSLI technology to the facts of the case was still not found to be improperly admitted. So even if it was just his master's degree and this happened to be the first case he testified for, I do not think that that would render it an abuse of discretion to allow him to testify. Are there any further questions from the panel?
Any further?
No, I did want to say that I found the chart on page 9 of your brief very helpful. So to the extent people are wondering if we like charts, at least I like charts. It's easier than a whole passage of text about a number of charges. So thank you.
Thank you.
Okay. That said, that case is done. I just want to make sure, Attorney Meth, that you drive back home safely as well, because there's no guarantee that the snow is stopped and the roads are clear. Thank you both very much for your arguments. We'll take the case under advisement. And now we'll reach our last case of the day. I remind everybody who's going to come up to argue this case that the case is impounded, so we don't use any of the names of the people involved. It's the Department of Children and Families and Another versus Mother, 2024-0536. Ma'am? Okay, so I'm going to refer to the mother as mother, and that's you, is that correct? Okay, you can stand up and you can come to the podium. I'm just going to give you a couple of parameters so you understand what's going on here. I'm assuming that you have not argued in an appeals court before, is that right?
Correct.
Okay, so when we refer to you as mother, department, son, we do that on purpose, intentionally, so that the names of the parties are not revealed, because this is a public proceeding, and we're being recorded, and people can hear this proceeding. It's not meant to be rude to you. That's why I'm not calling you by your name, all right? So that's why we refer to you as mother. Second, you should know that you have 15 minutes to argue, and you have to keep your arguments with respect to what happened in the record. Right? I think there's probably maybe things you might want to tell us, but if they're not in the record, we're not permitted under the law to consider those things, okay?
And by the record, are you referring to the
trial, the pleadings, the exhibits, all those things. And we'll help you out. If we think there's something that you might be talking about that's not in the record, we can point that out to you as we go along, all right? But I just tell you that now so you know that might happen as we go along, all right?
Okay.
Okay, so with that said, you have 15 minutes for your argument, and please go ahead and start now.
Thank you. So my son had been removed from my care quite a few years ago. They had concerns about educational and medical neglect. They also referenced that we had some housing instability. I just wanted to emphasize that during any time that there might have been a delay with tardies at school or any delay with medical appointments, there was something that we were suffering, a domestic violence issue that I was suffering, and then he had suffered an assault as well. We had been solidly living in an apartment for about almost 7 years, during which time I attended college and worked full-time, varying between each, kind of juggling the schedule, working to build a foundation for us. They had stated that I was largely unemployed throughout the years, and I thought that didn't give enough credit as to how busy my workload was, and probably why I hadn't recognized that there were some things happening to him with other providers that were helping watch him when I was working and going to school. But I just wanted to emphasize, I wasn't able to get his medical record because the office has closed, but we rarely had missed any appointments. If there were ever a missed appointment, I rescheduled, and I tended to all of his needs promptly. And if ever a delay, there was a reason for that. I didn't know if you would have liked for me to have brought that in, but I wasn't able to.
No, you shouldn't worry about bringing anything in, because as I was trying to explain and didn't do it so well, is that we can't look at new things that you bring in, but there was evidence about that at trial, and we could take a look at that, all right?
Okay. Thank you. And then motherhood was just my childhood dream. I adore my child, and I have another child now as well, and I'm just hoping to reunify my family as soon as possible. Things haven't been going well with his placement home. They are reporting that things are going well, but I know my son, and he would be happier with me. Every time I mention anything about working towards bringing him home, he gets really excited, and they continuously try to redirect my conversation and not allow me to remind him that he is wanted and that there are things that I'm working on addressing with the court to present that I am able to care for him well, that I am able to care for myself well and attend all doctor's appointments and educational needs. The housing instability happened a short time after I unfortunately didn't finish dental hygiene school, and I had car troubles because I wasn't working as much. I was in a condensed program. I wasn't able to pay for I was behind on rent, so we had to leave that apartment that we had for almost 7 years. But we were quite stable in that home for many years, and it was just a matter of not financial constraints and things like that. After suffering some abuse that we both suffered separately, we struggled to have the peace of mind that you would need to be able to learn new material and be able to focus on just flourishing in life. We were struggling in those areas. However, I just wanted to present that their concerns or their thoughts about the neglect in those areas weren't any neglect, weren't ever a lack of desire to care for my child. There were just circumstances that we were dealing with that people were hurting us or misrepresenting for myself.
I will say, even the judge found that there was no question about your love for your child. So,
I
yeah,
adore
that
him.
was came across quite clearly.
Thank you. I adore him. I honestly view motherhood as like a choice, a chance to be their humble servant and to build a future friend, because eventually he's going to be an adult. I don't have to own him or try to direct his life. I'm really all about just kind of helping him build himself and find who he wants to be in this world. And I'm really excited for the future bond that we'll have when we're able to have more mature conversations. Some of the things that they were talking about were about certain topics that we were discussing, but unfortunately we have been dealt a hand that others aren't usually dealt. And so we were unfortunately tasked with the problem of discussing certain life matters that we had. And sometimes during the visits, when I had visits with him with DCF, they would try to redirect the conversations, which to me was a bit troubling, because I thought to myself, how could we have this problem that we're facing, or that we have faced, like where he's placed in the kinship foster home with my biological sister. We're not, unfortunately, on good terms, and she's saying certain things to him that aren't appropriate, and so they have put in the record that there are conversations we're having that aren't appropriate, and it's a bit burdening to just have to discuss, hey, buddy, I know you've heard this or that, however, this isn't true, or what have you. It's just a matter of dealing with like family problems where he's placed.
There's no question. These issues are very difficult. I'm going to redirect you and ask you about something that's personal, and you can only answer the question if you would like to, but it's something that came up at trial. And since you're representing yourself, you're the person I have to ask, okay? So the judge was concerned about issues regarding your mental health, and you're taking care of yourself,
Yes.
and you're having the right treatment so that
Yes.
you come first, right? So that you can take care of yourself. Do you contest or challenge any of those findings? Was there anything there that you thought was not supported or not appropriate or anything like that?
Yes, so they were stating, I was reading through the file, and they were stating that there was like paranoid conversations that I was having, or things as a result of suffering assaults. I've suffered them since I was a little girl. My son has suffered them, unfortunately. And it's really a matter of just being aware. You know that the fire is hot. It's just a matter of knowing that there's danger, and knowing that you have to keep him safe from certain areas, from strangers, from different things like that.
So you would describe it more as overprotective? I think they have a term
bit.
for that. They call it helicopter moms, rather than a result of any issues that you have that you need to take care of for yourself.
Right. I have a document from a psychiatrist. I have a couple documents from a couple different psychiatrists that I was seeing. And they mainly focused on anxiety and depression due
Well,
to
there was
that.
evidence that you were doing quite well after one of your treatment periods,
Yes.
correct? Yeah.
Yes, things have been going well. I mean, I honestly I've gotten a lot stronger in dealing with like the misrepresentations and just dealing with the pain of having my child removed and then my second child removed. I've gotten a lot stronger and a lot more mature over the past few years. But I genuinely know that like any difference in my mood or is based on what I'm dealing with. It's not a matter of there's just a random, hey, I've got a different mood, or all of a sudden I'm not coherent, or like understanding what's happening around me. I'm understanding what's happening around me. I'm coherent. I'm of sound mind. I just have like a natural like anxiety about the problems, about the things that have happened with my child, myself, and just about getting him home with me, getting my children home, and just being able to get back on the path of working and just building our lives together and enjoying our memories, our bonds, and the time that we have together. I haven't been able to decorate for Christmas with him or just enjoy his birthday parties together as we would before, arts and crafts daily that we would do, just watching movies together and just enjoying life together. I miss him so much, and I know that he's happier with me. There's pictures of him with where he's placed, and he just doesn't have the genuine big smile as he did have when he was with me. And I know that that is his joy, to be with me, and he's like ecstatic about his new brother. Some days I think he's just kind of like, okay, there's someone else here. I think he's still processing that a bit, but I know that he's going to be a phenomenal big brother. He's really kind and tender and kind-hearted. But in regards to the mental health, I have some other documents from other psychiatrists. Unfortunately, I'm thankful that they were concerned, but unfortunately they just had the wrong perception about my mental health. It was really just a matter of, hey, some things have happened and I'm scared and I need help. And so that's why I was going to them, asking them for help anytime that there was a concern of him being injured or something like that. And for myself, I would usually go to a different place. But when he was hurt, I had gone to them and relied on them for support and followed up with all the doctor's appointments they had advised, counseling for my son, and really kind of kept up par with what they recommended in order to tend to any abuse that he was suffering.
Okay.
And I guess I'm disappointed that the last judge decided to continue to keep my child from me. I think mainly they kept focusing on the fact that there wasn't a shelter piece in place or a housing piece in place, which I have now. And all I have to do is get a document from the court that says that the custody would be returned to me, and I could apply that to the shelter, and we would get a bigger placement. I've gotten approved for a home-based rental voucher, which helps with covering rent for almost 3 years, while I would be in the waiting period to get housing. It's unfortunate because when I was in housing before, I was just about at $2,000 shy of having the down payment for a house, and that we were going to be able to move out of that system and be able to kind of rebuild something or build something more solid for his future so I could pass him down a house. And now I've got to start all over, unfortunately. But I do have like the housing secured, so he would have somewhere to go when he would be returned to me, and the same with my other children. And so I guess I'm just begging that you would review everything and recognize that I am capable of taking care of him and myself and providing a safe, happy home for him.
Okay. Well, I don't think there's any questions from the panel. Am I correct? No. We appreciate hearing from you. We know all these cases are always very difficult. And I just want you to know what our job is so that you don't leave here not understanding what we are going to do, which is we're going to review everything carefully. But we are constrained in certain respects. There's the law out back here and all these green and yellow books that tells us what the rules are that we have to apply. We have to apply them. And then, of course, there's findings by the judge who's in the courtroom that we have to give deference to. So we're going to look at all of that. But we do appreciate your being here today and emphasizing certain aspects of the case. And that's what our job is going to be, and we're going to do it, and we'll try and get back after. Of course, we're going to hear the other side, but after we hear both sides, we do try to get an answer to the parties as soon as we can. All right?
Thank you.
Okay. Now, the other side's going to argue. We're going to have lots of questions for them because they're lawyers, and I have some procedural questions, for example. I'm going to ask them, not you, because I expect that there's going to be some expertise in that area. But you won't be able to get back up and say anything. That's how we work. So now when you're done, you sit down, and that's sometimes frustrating. It's frustrating for lawyers as well. But those are our rules. All right?
Okay.
Okay. So you guys can take a seat right there, and we'll finish the argument. Thank you very much.
Good morning. May it please the Court, Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the decision of the lower court that terminated mother's parental rights. The trial court's decision was correct. The evidence in the record of medical...
Can I pause you for just one moment? I probably got this wrong, but I understood from the briefing that the mother's parental rights had not been terminated, but that custody of the child had been given to the department. Am I wrong about that?
I had the same impression.
Maybe we're both wrong.
Yeah.
That was my understanding, but I could be correct or incorrect, but ultimately the placement of custody outside of the parent's custody was the correct decision. The evidence in the record of medical and educational neglect, as well as housing instability, supported the decision that the child was in need of care and protection. The trial court considered all of the testimony and exhibits and found unfitness that was due to conditions that were not temporary by clear and convincing evidence. I'd be happy to try to answer any of the panel's questions, but otherwise I would rest on my brief.
Well, actually, the question I had was, what is the procedural posture of the case if a judge grants permanent custody to DCF, but doesn't terminate parental rights, but that's something that apparently is a little bit not clear right now, so it's not something that, I'm guessing that's not something you're prepared to answer.
No, I would just say in general, if parental rights aren't terminated, a mother or a parent can come back and request a review and redetermination
Right.
at some point and try to establish or reestablish fitness.
All right. Further questions? Seeing none, thank you very much.
Okay, thank you.
Good morning, Your Honors. Jennifer DeFeo. I represent the appellee child. On his behalf, we are requesting that this court affirm the juvenile court's decision to indeed give permanent custody to the Department of Children and Families. The judge did not terminate mother's rights. He looked at very closely mother's very recent efforts in maintaining a healthy relationship with her child. For the first time in many years, she was showing more consistent and more appropriate parenting time. She was also, for the first time, showing some actual evidence that her mental health was being treated. There were still grave concerns, especially her comments during the foster care review when she stated she did not know whether she would continue to take her medication. And I do think that the judge was focused on the fact that she couldn't meet the child's minimal care at that moment. He was giving her the opportunity to continue on an upward trajectory. And if she was able to do that, as Attorney Price indicated, she would have the right to file for review and redetermination.
Well, let me ask you a question, because I am a bit perplexed procedurally. The judge also ruled that was in the best interest of the child to be served by a decree dispensing with the need for consent to notice of adoption. So how does that compare with the possibility that the custody could be returned because parental rights have not been terminated?
Only the father's
It's only the
parental
father.
rights
Okay,
were
so that's apparently
terminated.
that's the answer of why it was difficult to understand. Okay.
Correct. And it was a little confusing because the hearings were bifurcated, but he was very clear that he was giving mother the opportunity to continue to make efforts.
So that particular portion of the decree applies only to the father,
Correct.
as your understanding. Thank you
Yes.
very much.
You're welcome. So, Your Honor, just to address some of the facts that were raised in the appellant brief, even if the judge did make a couple of clearly erroneous findings in regards to the housing issue, there's some contest as to whether or not she was actually evicted and prevented from going back into a SMOC housing. It doesn't matter, because there is no prejudice. There was such an overwhelming constellation of facts that showed mother was unfit that it should stand as it is. And where a lot of that is factually based, I will not go over it unless you want me to.
Not necessary.
Thank you. But I will state that I have met with my client. He does, at this time, maintain his position as an appellee. He, at this moment, wants his preference to be known. His preference is to remain in his current placement. He is bonded with his kinship aunt as well as his cousin. And the real factor here is his needs are finally being met fully. He's enrolled in school, he's showing that he's progressing on his IEP, which was all brought out during the trial. So to disrupt this at this point without having a review and redetermination where mother shows her preliminary burden, which is just some credible evidence that she continues towards a metamorphosis, at this point, we are asking that it be affirmed. And if there are no further questions, I will rest on my brief. Otherwise, I do have quite a few arguments that I can make regarding the appellant brief.
I have a factual question and then just a request for education. Is the child is 15 now, is that correct?
14.
14, okay. And in your experience, obviously not holding you to this, how long would a review and redetermination process usually take if the mother were to request that?
So I unfortunately can't answer that. I only do appeals. I
Okay.
don't do it at the trial level, but I will state that she has the absolute right to bring it as of today. She only had to wait 6 months after the March 2023 finding of her unfitness to do so. But I can assure you, Your Honor, that it would be much faster than this process has been to get it through the appellate process and before you all.
Okay.
If you
Thank
like,
you.
I can address the reasonable efforts and all those other issues.
We don't, we have your briefs, we've read them thoroughly, we'll be reading them, of course, again, so we don't need to have any more explanation. Thank you very much.
Thank you very much.
All right, thank you all very much. If any of you are traveling west, we understand that it's a little bit difficult out there, so please be safe, and